Okay, good afternoon, folks. We are returning to our discussion of S-193, an act relating to establishing a forensic facility for certain criminal justice involved individuals. And we have with us this afternoon, Barbara Lee. Barbara, welcome. There you go. Welcome.
Hi.
This afternoon, and we have a copy of Barbara's testimony. So, Barbara, if you wouldn't mind describing or introducing yourself, and then what your role is, that would be wonderful for people to understand. And then we would love to hear your testimony.
Great. Thank you very much, Madam Chair, for this opportunity today to testify in front of this committee. I am Barbara Lee, a retired physician and an advocate for individuals and their families with intellectual and developmental disabilities. My 37-year-old daughter has a rare neurological disorder, which includes an intellectual disability. I serve as co-chair of the State Program Standing Committee. This committee is a governor-appointed body with the mandate of advising the Developmental Disability Services Division on the statewide system of care, including policies, service needs, priorities, and how resources should be allocated for people with developmental disabilities. We also evaluate applications for initial or redesignation of service agencies within the system. There are 15 members on the committee. We are self-advocates, clinicians, academics, agency administrators, attorneys, family members, direct support personnel, advocates, and interested citizens. Quite an eclectic group. 3 years ago, Act 27 proposed the establishment of a forensic facility which would include persons with intellectual and developmental disabilities. A working group was formed to study the issue. In October of 2023, the State Program Standing Committee voted unanimously to strongly oppose the proposed plan that people with intellectual and developmental disabilities could be housed and treated in a forensic facility. In our letter to the working group, we stated, instead of placing people with intellectual and developmental disabilities in a forensic facility, we recommend that the state of Vermont allocate the necessary resources into the home and community-based services system, which supports people with developmental disabilities in the least restrictive setting. In the 1990s, the state of Vermont recognized that placing people with developmental disabilities in institutional settings was wrong. And subsequently, the Brandon Training Center was closed. Since that time, housing, supports, and services have been successfully implemented in community-based settings. Now, here we are in 2026, and the establishment of a forensic facility is being discussed as part of S-193, and there is talk of including people with intellectual and developmental disabilities in this forensic facility. At the March meeting of the State Program Standing Committee, the committee again evaluated the appropriateness of housing and treating people with developmental disabilities in a forensic facility. We discussed one of the major purposes of a forensic facility: to house people who have committed serious crimes but are unable to go to trial because of significant mental health issues. Then treat them in the facility until they can be, quote unquote, restored to competency in order to stand trial. People with developmental disabilities cannot be restored to competency. People with intellectual and developmental disabilities it's a lifelong situation. The disability in and of itself cannot be cured. Though, with proper support and therapy and education and compassion, adaptive skills can be improved and the quality of life of these individuals can be enhanced. On March 19th of this year, the State Program Standing Committee voted unanimously to oppose the use of a forensic facility for people with intellectual and developmental disabilities. We wrote a letter to the commissioner and to key legislative chairs expressing our opposition. We requested that the specific language of qualifying conditions be amended to exclude people with intellectual and developmental disabilities. We are not aware of evidence to support that people with developmental disabilities can be restored to competency. May I also emphasize that we need to ensure that community providers have the critical tools to support the small number of people served within the developmental disability system who would otherwise be routed to the proposed forensic facility. Examples of such support include: 1, an adequate rate for services, which would likely need to exceed the enhanced rate that's currently available. 2, access to clinical expertise, including via telehealth. And 3, the ability to use locks and barriers as necessary to guard against elopement. All of these measures are likely less costly than placing people with intellectual and developmental disabilities in a forensic facility. So thank you, and I'd be glad to take any questions or comments.
Thank you, Dr. Lee. I think that we're going to hear from Barb Prine first, and then we'll take questions for both of you at the end of that, okay?
Great, thank you.
Thank you. Welcome, Barb. It's nice to see you. And thank you for being here today. And if I don't believe we have any written comments from you, we do have Dr. Lee's written comments on behalf of the State Program Standing Committee. And I'm presuming you are still on the State Program Standing Committee, are you? Or
I am still on the State Program Standing Committee.
Okay. So today we would really be interested in your experiences in your work representing individuals who have likely committed a crime but have been found not competent to stand trial, and your experiences with the service system and sort of ongoing nature of their commitment under Act 248 and the judicial review process.
Okay, thank you, Chairman Wooden. It's nice to see you too. My name is Barbara Prine. I'm a staff attorney at Vermont Legal Aid. I work half-time in the Disability Law Project and half-time in the Poverty Law Project. Most of my career has been spent in the Disability Law Project up until about 6 years ago when I started splitting my time halfway between. But I've worked for Legal Aid for more than 30 years. And I have, as a part of my job, a small part of my job, but a significant part of my job, I represent people who have been committed under Act 248 to the custody of the Commissioner of Dale for an appropriate program. And so I've probably represented, I don't know, at least 40 different people in their annual reviews, maybe 50. It's hard to tell because it's been so many years. Um, and so I've been meeting with people, talking to them about their programming and dangerousness and stuff like that. These are people who have been accused of committing serious crimes, have been found not competent to stand trial, and who are receiving services in the community. The services are with a difference of intensity of services, sort of depending about the individual and their needs. The first thing I'd like to say is uh, we do not believe that people with intellectual disabilities should be part of S-193. We do not believe it's necessary, and we think that if you allow people with intellectual disabilities to be in S-193, there will be an over-reliance on that. It will be more expensive. And once that is set up to happen, people who are being completely appropriately served in the community now will be committed to the forensic facility, and it'll be really hard for them to get out. So I just want to start off by saying that I have reviewed yesterday and today's draft. I got a new draft early this morning, draft 2.1. I don't quite understand. I haven't had time to quite understand all the differences between the two drafts. And so at some point, if that becomes relevant or if I'm misspeaking, let me know. I want to talk about the issues of what works for people based on my experience. I want to talk about competency restoration. I want to talk about the issues of due process, and I want to talk about, is corrections therapeutic? And I say all this, I'm not a clinical person. I'm a lawyer who has specialized in representing people with disabilities. More than half of my clients have had intellectual disabilities over the years. So competency restoration, I just want to remind everyone what competency is. Competency is tough for a person with intellectual disability. It means, do you understand the proceedings? Can you sit through a trial? The trial might be a day or two long. Can you tell your attorney that you think that this person is lying and why you think they're lying? Can you understand trial strategy? Do you understand the role of the prosecutor, who is not your friend, even if they're friendly? Do you understand the role of the judge? Do you understand the role of a jury? Can you answer complex questions, especially leading questions? Can you help your lawyer? Can you stay focused through the whole time? This is very hard for very, very many people with intellectual disabilities to do. And in my professional experience, it is not something that can be restored or brought to someone who has an intellectual disability, because it's a lot of complex thinking. And in my experience, most people, not everyone, but most people with intellectual disabilities don't have that kind of strategic, complex thinking. There can be a tendency to trust people more. I read one competency evaluation where the person was asked what the role of lawyers, and they said the job of lawyers is to bring joy and happiness to everyone. And surprisingly enough, that person was found incompetent to stand trial. But honestly, if you think in your trial that all the lawyers are supposed to bring you joy and happiness, you are not going to really understand what's going on in that trial. So I do think that people can get better, that people can learn to improve their behavior. And I want to say, even though I represent people who often want to be off Act 248, and I've had contested hearings where people have tried to get off Act 248, most of the time people lose those hearings, even though they have a very good attorney. Most of the time they lose those hearings because you really have to show that you have learned to improve the behaviors that led you to this place. And people do get better and improve behaviors, but a lot of it is about having consistent, caring staff people who are able to set boundaries, appreciate you, find your value, see the positive in you, and do that year after year. And so I have had clients who have gotten Act 248 who have learned to improve their behaviors and have learned strategies. A lot of it is strategies to avoid problem situations, but learning strategies to avoid problematic situations is not the same as learning how to sit through a trial, what a role of a judge and jury is, that the contingency thinking, like those are intellectual things as opposed to a behavior modification approach, which is a lot of what treatment is about. I have had many clients who the first time I have met with them when they first get on Act 248, they've been threatening and aggressive and angry. And over the years, that changes as they work with folks who provide good structure and support in the community. So I don't think that I have not had an experience where I believe competency could be restored. I have had experiences where I see strong quality programs in the community work to help people learn more about conforming their behavior. And I want to say, I have like mostly the problematic area is sexualized behavior. There's some threatening and violence behaviors for some of the people on Act 248, some arson, but a lot of it is sexualized behavior. And I think in our culture, especially men, the whole idea of what consent is very complicated in our culture to be taught to men. And then if for people with intellectual disabilities who do not have good home supports and structure, it can be very complicated to understand what's okay and not okay, especially if that person has been abused themselves as a child. So I think that the place that more people would end up in would be people who are under Act 248 who have had sexualized behaviors and need a lot of intensive supports to learn to get past that. That's not the same thing as learning how to be competent. I want to address one of the things that I heard this morning is people's right to be heard about and prove their innocence. I have never had, in the hundreds of conversations that I have had with clients over the years, and I don't know, I just want to say I've represented 40 to 50 people over the years. They have annual reviews. So some people I represent year after year after year. I've never had someone say that they wanted to go back and prove their innocence. I've never had people say they want to go back to court and do that. That has not been a conversation folks have had. I have had a tiny number of people say to me things like, well, the reason why I punched him and hit him and kicked him in the stomach was it was really all his fault because he did this other thing. So I've had people believe that they should not have gotten in trouble and simultaneously admit to the alleged criminal activity at the same time. But I've never had someone say, I want to go in there and prove my innocence. I want to go back to court. Court is fairly traumatic. Not traumatic's a strong word. A lot of my clients would rather do anything than go to court because they feel stupid in court. They don't understand what's going on. it's like if the fate of your life was decided while you sat through an advanced physics lecture that you didn't understand. And at the end of it, it was going to decide something that happened to you. That just the feeling like, I don't get this. I don't know what's going on.
Barb, Barb,
Yeah.
I'm gonna have to leave in a couple of minutes and the committee will ask you questions, but I have one question I want to ask. And I really, really appreciate you being here because I know it's not your favorite thing to do. In your experience, and I think you probably have the most experience in the state, frankly, of representing people in this situation. And then following them through,
Mhm.
once they have been ordered to Act 248 and they continue, they receive services in the community. Have you experienced, has the community supports that have been in place for your clients been able to provide the community safety that some of our witnesses spoke about this morning? They identified S193 as being primarily about community safety. And have you experienced the ability of the programs that are being provided to your clients as also, in addition to what it's doing to help your client, but also protecting the community's safety?
Yes, I have, with a few small caveats. Yeah, people have staff that are hands-on and one-on-one. People over the years graduate to, if things are going well for them and they're able to conform their behavior to like arm's length or eyes on supervision. Sometimes people eventually get to the point where they can go to work or be in the community without having a staff person with them. Some staff people get hit by clients early on in the program. So I just want to be honest about that. Like some of the designated agency staff have been hit or shoved. But that is the extent of what I've heard. And I would also add, some people hear sexualized talk in inappropriate settings. And I think sexualized talk is different than sexual acts, but someone might be with someone in the grocery store and they might say inappropriate things. Those are I mean, there are other things. There are some people who are trying to elope and get brought back. There's a provision in Act 248 orders that people have to be brought back. If they run away, they can be brought back by a police officer. I mean, I did hear Stuart say that people are tougher than they were in the past, and I would say that I think that some of that is true. But I think that the problem that's trying to be solved is more a problem in the mental health arena than in the intellectual disability arena. And I also want to say, I have had a couple clients, and I'm sorry, Chairwoman, I don't want to take too much of your time, but jails are very destabilizing for people with intellectual disabilities. I've had a couple clients who have been stuck in jails or prisons, and they are victimized there. And it is really hard to follow all the rules in the jail. And if you don't follow all the rules in the jail, you end up in segregation. And I have had clients end up in segregation because they cannot conform their behavior to the rules of a jail, because it's like a high social, high stimulation environment. You get ordered around a lot, and I haven't had a client who's not come out of jail with more behavior problems than they went in. It's just not, I don't think you can treat people with intellectual disabilities in jail, even if you make it a kinder wing. I just don't see how that can happen.
Thank you. Thank you, Barb. And I apologize that I have to scoot off to another commitment, but Representative Garofano here will continue. And I really want to express my thank you to both of you for being here today and giving us the perspective of people who have worked in the system or have had relatives be in the system and have advocated for people, you know, through your roles in policymaking and actual, you know, representation of people with direct experience. We kept hearing this morning how we were maybe that we shouldn't be even talking about Act 248, that we should just be concentrating on this. And I guess I respectfully disagree, because why would you have another system do something that is already being done under current statute? You know, in terms of what the objectives were for the witnesses, but appreciate you both being here, and Representative Garofano is in charge now.
Representative Garofano, if I just could say one more thing.
Sure.
I think that Act 248 does 95% of what it is trying to do. And I think if S193 goes through, including people with intellectual disabilities, instead of picking up that 5%, it'll be picking up 50 or 60% of the people under Act 248. It'll be over bringing in, because there's no mechanism in this to figure out if Act 248 can work or not. It's all about competency and competency restoration, which is the wrong question for this group of people.
Thank you. Go ahead, Representative Bishop.
Yes, Attorney Prine, a question for you. This morning, we had testimony from Commissioner Bowen about the Slater method, an approach to get competency attainment for trial, and that there's a study that indicated that it had 61% success rate, which was far in excess of any other methods that were in the 10 to 15% range. Are you familiar at all with that?
No, I Googled it. I've never heard about it. I mean, I have been doing this work for 30 years and no one's talked to me about it before now. And I do think I mean, I'm glad you asked the question. I can't intelligently speak about it, but I do think it's the wrong question, right? The question is, how do we keep our community safe? Not how do we restore competency? And because we want to keep our community safe, and restoring competency just means then the person might then be found guilty and go to jail, and they were in a forensic facility. Like, I don't think those things make a person or the community more safe. I've already said, I mean, I've had clients who just come out so traumatized from jail. So I don't think that jail helps our community be more safe. For people with intellectual disabilities. I don't mean to say that across the board. I'm not saying we shouldn't have prisons. I'm just saying that it is not it doesn't appear to treat the clients that I serve, that help treat them and help them be better.
I guess if I can,
Yeah,
the commissioner of the Department of Corrections and others who testified this morning said that they already have in their population people with developmental and with intellectual disabilities. So those individuals, they say, are in the system and that they are providing supports. I'm curious to see what those really look like. Would have to, but so to make their argument, perhaps they would say that if there is some level of competency attained, restored, however we phrase it, then the appropriate place is within the court system for disposition, whether that's a finding of guilty, not guilty, whether that's results in jail time or doesn't result in jail time. So is this just a philosophical difference about how we support and serve people with intellectual disabilities, or do you see it differently?
Well, so let's say the person has competency restored, goes through trial and is found guilty. I mean, everybody has to have a show cause hearing that it's likely that something happened before, in a part of the determination that someone can even be committed to Act 48, because there has to be a finding that they presented danger of harm to others and that they committed an act that is a danger of harm to others, one of the serious things. So I think most of the folks are going to get found guilty and then they're going to be in prison, right? So then what happens? Like, I want to tell you like how my clients get in trouble in prison. I had a client who liked his case manager. So every time he saw his case manager, he jumped up and ran to the bars and he was like, "Hi, John, hi, John, hi, John, hi, John, hi, John, hi, John." And he didn't stop that. He did not stop that. He was happy to see John, and he got disciplinary infractions for that because it was disruptive. That is actually disruptive in a prison to do that. But he couldn't manage his behaviors to not be excited and control his impulses. So anyway, I think that I don't know about the Slater method for making people competent. I just think I don't think it's the most important thing to do, because I'd rather focus on, like, for example, clients in my community, if they have a fixation on children, then they have to learn behaviors to stay away from children, safety plans so that they don't interact with children, things where they feel good about themselves instead of bad about themselves because they're less likely to offend, living situations where they're not going to encounter children, jobs where they're not going to encounter children. Those are different things than trying to learn the role of a judge and jury in terms of future community safety and what we put our resources into.
Yeah, I'm not familiar with the Slater method either, other than doing a little Google research. In the interim, it seems to me that it's, at best, it achieves some sort of competency light, if you will, and only within a very narrow context of a legal proceeding. So, yeah.
Are there other questions for the witnesses? Go ahead, Call.
One thing we talked about this morning was that my understanding of why the scope of who would be included, at least in the list of qualities, was longer, including folks with IEPD and mental health, maybe co-occurring situations. I guess I have a question about how I see serious problems with how that would be addressed in this situation, kind of lumping together one and the other, but I am curious too, with mental health disorders, basically, what missing gaps do you all see? Maybe even having experienced it through clients with IDD or without. I don't know if that's you've had experience without as well, but you know, talking about that missing 5% that needs to be filled with the system that we have today and needs to be improved upon.
I mean, I would say the missing 5% is like helping set up systems where staff members aren't hit, but that's complex and it involves some more complex training that I think is expensive and our system would need to work on. It's not as expensive as a forensic facility. For people with mental illness, that hasn't been a group that I've represented in my years, just by the way that legal aid works. Jack McCullough, who I think has testified for you before, is the person at legal aid who does the mental illness work. So he would be a better person to ask than me on that question.
Thank you.
Go ahead, Robert Black.
Thank you so much for your testimony. What's the core distinction between a mental health facility and a forensics facility?
Well, we don't have a forensics facility, so we don't really know.
No.
But
I'm just asking what's you being in the field. What's the core distinction between a mental health facility and a forensics facility?
Yeah, I do think what was interesting that I heard this morning from acting Commissioner Murad. Is he interim commissioner, acting Commissioner Murad?
It's full now.
It's
Full
full now.
full Commissioner Murad, is that he sort of acknowledged that it's probably gonna be in Springfield Prison in the mental health portion. I don't know if it was him or, the Commissioner of Mental Health who said that they thought that was gonna be most likely. I have been in prisons. I've been in like 5 prisons in Vermont, and I've been in Brattleboro Retreat, and I've been in various mental health facilities. I think that my guess is a forensic facility would be kind of end up feeling like some of the semi-secure parts of Brattleboro Retreat if you were in that space, newer or rehabbed. But I don't know how different I don't know I don't know how much you'd have to be training the correctional. Are you going to have different staff? I think there are some questions here that Commissioner Murad said he didn't know the answer to. Are you going to train different staff there? He said, I couldn't have one person just in charge of this in good conscience with his limited staffing. So like, how is that all going to work? Are correctional staff going to do it? And correctional staff, like a lot of them are really young and are trying hard, nothing against them, but it's not enough pay to get people to stay in it, and it's a hard job. So I am curious about how all this would work and how it would actually be different. It might be a slightly nicer wing of a prison with slightly nicer facilities, but I also have to say, like, when you go to Brattleboro Retreat and some of the intensely locked places, it is grim. It's pretty grim. It's not a place that I think would help me get better if I was having problems. And I do want to say one thing. Most of my clients, like most of their days are good days where they are, working in chicken farms, working in factories, working as janitors, working on assembly lines, like learning how to be responsible in the world. So the aggressive part is a small part. You want to get that not to happen. I don't want to minimize it, but I also want to, they're full human beings with good parts and bad parts,
What I was getting at is, I think there's been like some discussion in regards to, we're looking at 2 different things. A mental health facility is to treat diagnosis. A forensics facility exists to manage individuals whose mental health intersects with the criminal justice system.
Yeah.
Now, with that, the core distinction is just that. Forensics facilities are based upon legal status and purpose, not diagnosis. Mental health facilities are based upon diagnosis. There is no way legally, and it goes back to the ruling of Jackson in Indiana from 1972 that established how forensics facilities in a context can operate with people with disabilities. There's no way, any way, shape, or form, unless that individual does not, if they are not intersecting with the criminal justice system, they cannot be placed into that facility. It's constitutionally, it's against the law. So what I'm kind of getting at is what 193 is doing is establishing forensics facility. Whatever that looks like is bound to be known. Under the governance, right now, full governance is under the Department of Corrections. There needs to be dual governance. That's a different thing. But what's being fed back in your examples, unless they are under, have been incompetent to stand trial or under any high level of supervision with the Department of Corrections, they can't be placed there.
Mhm.
That's what I'm getting at. We
Yeah.
do need a facility that does help fill that gap above for these cases of egregious crimes found in competent to stand trial or NGR. And the restoration that's kind of written within the bill, the competency restoration, primarily drives the IST purpose, incompetent to stand trial purpose.
Yeah.
You know, so I'm not disagreeing with the things you're saying. I'm just trying to get back to
Yeah.
the clarity of where things are at, because I see we're kind of maybe turning on off and integrating two completely separate populations and putting them into one bucket, expressing that individual that's struggling with intellectual or that has intellectual disabilities hasn't done anything wrong in regards to, you know, coming under the criminal justice center, is actually being, to an extent, categorized with possible forensics cases. And I don't want to see that happen, because that's, to me, that's a misjustice. That's a complete injustice. So thank you.
Other questions for the witnesses? Okay. Thank you both. Oh, go ahead, Barbara. You had
I was
something
just
to
gonna
add?
say, thank you for your time and for caring about these people and really thinking about how we keep our community safe and how we do our best to recognize, you know, the humanity and the potential in everyone to do better. So I really appreciate the amount of time and attention you're putting to this. Thank you so much.
We really
Thank you.
appreciate your continued work and advocacy for this population. Your testimony was extremely beneficial and informative. So really appreciate you taking the time to be here.
Thank you.
Okay, committee, I think that wraps up our afternoon today. So we can go offline. Thank you, Lori.